If I could just support what Faisal has said, I mean, to my mind, it's just an unjustified judgment. And it's not the first judgment of its kind, unfortunately, and that actually brings us to the larger questions that both Anisa and Vakas and Mehek have raised, that there is interplay between what society is doing, what the courts are doing, and what the powers that be within the state structure are doing. So the Constitution as written is always being kind of rewritten, as it were, through our court judgments and through how we actually implement it. The 63A judgment is a particularly egregious, to my mind, example of that kind of a rewriting. Not only was the fact that there was a proposal not accepted by Parliament ignored, the fact is there was Article 96 in the original Constitution, which said that votes against party directives in certain matters would not be counted for a period of time, and that provision was then expressly removed. And in effect, the 63A judgment has read that provision back into the Constitution. So I can't find any way to justify this judgment. But it follows a long line of judgments that I can't justify. So as somebody who's been around now for 31 years in High Court and Supreme Court practice, you know, I could start right from the year 1992-93. I was there when the Nawaz Sharif case of 93 was being argued. I was assisting my then senior Saqib Nisar, who was assisting Khalid Anwar Saab. So I went through that hearing, all 15 days of it in court. And I know what happened then, and I was privy to some of these arguments in the office as well, how that whole argument developed. But that